Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Today is Tuesday. We're here at 10 a.m. for another episode of the Bottled Business Sense show. And for today's episode here, Bill is going to speak on a topic called business, debt, and marriage. But before we get to that, I wanted to introduce Bill. How you doing today, Bill?
Doing great. I was hoping you'd get around to doing that, Rick. How are you today?
I'm doing great. We
Good.
are almost... we're just here in the beginning of the new year, right? And
we are. We're waiting to roll in the new year, and hopefully it'll be another prosperous year for all of our viewers and listeners. And we do this show for educational purposes. We try to help the small business owner, the entrepreneur, the business owner who has employees, or maybe a solopreneur. And we try to give them helpful business tips in the areas of business law, which would be estate planning, asset protection, and of course employment law. And of course we try to promote that business, move that protected ship in a bottle, if you will, along by providing marketing tips that we think will be specifically helpful to the small business owner. So we're glad to be here. We're going to hope everybody has a prosperous holiday season as well, but today we're going to really focus on business, debt, and marriage, which I thought, Rick, would be an interesting topic.
Yeah, you got me interested in that topic. It's definitely an interesting mix, but I'm sure it's all intertwined. And
right.
For you and I being married, I'm very curious to hear what you have to say about it.
Well, let's start out. Let's start out by separating it out into two basic groups. We have a handful of states in our country that are called community property states, and that simply means that the debts incurred by one spouse, of course, will be incurred by the other spouse, and we're going to get into that a little more. But then we also have what's typically referred to as the common law property states, and basically these are debts that are incurred by one spouse, and in those states, the debts are usually that spouse's alone. That is, that the spouse that incurs the debt is the spouse that's responsible for the debt. So we're going to kind of break it up, Rick, and we're going to try to, kind of talk about community property states versus common law states.
Okay, and this isn't what you're talking about here. Doesn't necessarily apply yet in your discussion to business, right? This is individual debt.
Well, it applies to business because don't forget, businesses can incur debts, and businesses can be a house for assets that might be used to pay off the debt. So it's very important as part of your asset protection setup that you want to be aware of what you're responsible for before you become responsible for it, so to speak. And you want to find ways to maybe protect your business so it's not going to be put in the liability pot and be used to pay off debts that you may or may not be responsible for. So I want to start off again by saying there is a major distinction between community property states and common law states. And remember that these rules we're about to talk about apply to same-sex marriages in states that allow same-sex marriages, as well as domestic partnerships and civil unions. So we're not just talking about the stereotypical marriage that we used to talk about by itself in years past. So let's look at some community property states. Basically, community property states are going to be Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. And since we're in California, we're gonna want to be taking a close look at community property debt laws. So here, Rick, is the general overall idea. Most debts incurred by either spouse during a marriage are owned by the community. The community is the couple. Even if only one spouse signed the paperwork for the debt, the key is that during the marriage, the debt was incurred, okay? Mm-hmm. So if you incur a student loan while you're single and then you get married, it won't automatically become a joint debt unless the spouse signs some sort of a document that allows the spouse or makes the spouse jointly liable for the debt. So let's assume you have a student loan that you incurred while you were single, but let's also assume that you refinance that loan, and now as part of the refinance, your wife signs the documentation to get the loan. Now all of a sudden that separate debt has become a joint debt. So you really need to be cognizant of that. Remember, it automatically single separate debt that you have before you get married will not automatically become a joint debt just because you get married. You're going to have to do something to make it become a joint debt. So that's the first thing that you want to do, and remember, and also remember that even when you get a legal separation or a divorce, okay, a debt is generally owed only by the spouse who incurred the debt unless it was incurred for family necessities. Okay, so let me explain that a little bit. Let's say you have a legal separation or a divorce. A debt that is generally owed by only one spouse, okay, because it was a separate debt coming into the marriage, may become a joint debt if it was used for or incurred for family necessities to maintain jointly owned assets, or if it was put in a joint account. So let's say you have let's go back to the student loan. You refinance the student loan, and as part of the refinance now, you've taken out a little extra money than what you already owed for the loan. It can become a joint debt because now the spouse has incurred the indebtedness as a result of also filling out the loan application. Or maybe the spouse didn't participate, but you used the extra money from the refinance, and what you did was you used some of that money for family necessities, perhaps food, clothing, or perhaps you used it to maintain your home, which is jointly owned. Now all of a sudden, this can involve a joint debt situation.
Okay. If the debt was left alone, and it was your student loan, and you got divorced or separated, then the status or the liability of that loan doesn't fall jointly; it falls with the originator, right?
That's right. The person who owned it before the marriage is the person that owns that debt after the marriage. Mm-hmm. Now you may also incur your own debt during marriage, but not use community property, that is income brought in by the community, to purchase that debt, purchase the object of the debt. So for example, you're married, you buy a car with an inheritance that you received prior to marriage. That inheritance goes to pay for the car. After the divorce or the legal separation, there is no liability by the other spouse for that debt unless perhaps the spouse participated in using that vehicle for some joint responsibility that the married couple had, such as taking the child back and forth to school in that car every day. If it was used for some family necessity, or if it was refinanced, perhaps to pay off some joint debts, now all of a sudden there may be an issue where the spouse who didn't purchase the vehicle by way of the inheritance could become liable for that debt as well. But generally speaking, a separate debt remains separate unless it is incurred by joint community property, and joint community property would be any income that's made during the marriage. So if you're making income during the marriage and you decide to buy something, that's going to be a joint obligation by both spouses.
So are you saying then, if I have this, let's say for instance I have this inheritance and I use that inheritance, it's a sizable inheritance, and I bought a Ferrari, right?
Mm-hmm.
Then I got married, and my wife wanted to drive that Ferrari, and then we got legally separated or divorced. Are you saying then, because she was driving it to and from to go shopping, that she would ultimately also share in some of the debt responsibility?
Let me put it this way. The debt itself wasn't incurred for family necessities. In other words, and I apologize if I didn't make that clear earlier, if you got this car by way of an inheritance, which was your separate property, but you bought the car specifically so your wife could go to the market and get family necessities every day, or so your wife could take your child back and forth to school every day, if that's the reason the car was bought, an argument could be made that the other spouse is liable for that debt as well. However, if you buy the car strictly from separate assets, from an inheritance, for example, and your wife just happens to drive the car, no, I don't think the argument would be very weak that she's also liable for that debt. Okay,
that helps clarify it.
Okay, and I'm sorry if I'm sorry if I was a little confusing for everybody there at the beginning, but really it has to, a separate piece of property, a separate debt incurred prior to marriage, or a separate debt incurred by way of some vehicle that by some separate property that you use to purchase something during marriage, that remains a separate debt unless that debt was incurred for family necessities or to maintain some jointly owned assets such as a home, or if all of a sudden you take that inheritance and you put it in a joint bank account that's an account for both you and your wife, now that inheritance, which was separate property, could be argued to be joint community property because it was put in a joint bank account.
Okay.
So you always want to keep your separate property separate and your community property community.
That makes total sense.
And I guess that's what the divorce is all about, right? Everybody argues what's what.
Yeah, that's true. All right. Well, that's
and this
great.
I want to emphasize, Rick, this really isn't a lesson in divorce and marriage. This is really getting down to, what if you own a business? And what happens if you own a business? Can this business be liable for the debt of your spouse? Well, it was community income used to purchase this business. Okay? Was the business purchased with your own separate assets? If your business was purchased with your own separate assets and your wife isn't entitled to the business, you could make an argument that this is separate property and that your business should not incur the debts of the other spouse. So,
yeah, that makes total sense, and I have a question that I think is probably of interest to viewers. But before I ask that question, I think it's a good time for us to take just a brief break here and talk about one of our sponsors here.
Okay. Yeah, let's talk about one of our sponsors that we have done business with in the past and has always been very helpful providing insight for investment purposes to the community. His name is Rick Regal, R-I-E-G-L-E, and Rick is located at Edward Jones at 30110. That's 30110 Crown Valley Parkway, Suite 104 in Laguna Niguel, California, 92677. And Rick provides great investment advice. And here's the beauty about what Rick does. He can provide you sound advice for the small investor. And I mean small. I mean, you can have an investment account of 20 grand, and Rick can build that thing up in a hurry, or you can have a rather large estate and want to invest it, and he will tell you what vehicles you need to make that estate sound. In other words, do you want to have some in very conservative investments? Do you want to go long-term, short-term? Do you want to get into more speculative investments? He'll be able to guide you in that regard. So please feel free to contact Rick Regal. He's an investment advisor at Edward Jones in Laguna Niguel. And Rick's phone number is 949 area code 249 8248. That's 949 area code 249 8248.
Excellent, excellent. So we'll have that information here posted below this video, so you can contact Rick with your financial needs. So, folks, we're here with Bill Bernard. This is the Bottled Business Sense Show, and we are talking today about business, debt, and marriage. And Bill, in the top half of the show, was talking about non-community property states, and he gave us some examples of that. So
actually, we were talking about community property states. We haven't gotten into the.
I'm sorry. I misspoke. Right. I had my notes down here and transposed it. We were talking about community property states.
Right.
And so my question to you then, in the example that you gave, is that what happens in non-community property states in the examples that you had given us here?
Okay. We're going to talk about non-community property states right now, Rick. However, there was one last part of this topic I wanted to provide to everybody. And before we leave the community property realm, and here's what it is. Let's say in a community property state, you ask the question, can the creditor of one spouse go after the assets and income of the married couple to make good on joint debts? Okay? Creditors can go after joint assets in a community property state no matter whose name is on title. Okay? Mm-hmm. So, if you have joint assets because you're in a community property state and community income has contributed to those joint assets, it doesn't matter who's on title. And this goes directly into our notion about how a business can be affected. Let me give you an example. A business owner's name may not be on title to her spouse's boat, but in most community property states, that won't stop a creditor from suing in court to take the boat to pay off the business owner's debts, assuming the boat was purchased with community funds and not separate funds. Okay? So if you purchase that boat with community funds, that is income that is coming into the household during marriage, right? Mm-hmm. Then that all of a sudden makes that boat a what? A community purchase, right?
That's right. Yep.
So that won't stop a creditor from suing in court to take the boat to pay off a debt that the business owner, the other spouse, may have, right? Title doesn't matter in that instance, Rick. So basically, a business owner's name may not be on title to the spouse's boat, but the boat was bought with income that he brought in and she brought in. And so if he's got separate business debts, the creditors can go after that boat to pay off his business debt. So what does that ring true to, Rick? What does that remind you of that we've talked about in so many of these past weeks, right?
Yeah, we've talked about a lot of stuff, and I'm sure you're going to remind me right now here, Bill.
We are talking about getting a business entity, right? And operating your business through the business entity, right?
Right.
Because if you're a solopreneur and you don't have a business entity, and your business entity isn't set up properly, and you're not operating the books properly, now your personal assets are exposed to business debts, including that boat that you bought with community funds that you're not even on title to, can be utilized to pay off this business debt that a creditor comes after. So remember now, when you purchase a home or you purchase a boat or you purchase an asset, remember, title is different than legal responsibility for the loan obligation, right?
Right.
You have a loan obligation, you sign loan docs. The loan docs are what's going to control. So a bank or some creditor only cares about who's on the loan docs or how this money bought this asset. If it was bought with community funds, it doesn't much matter whether you're on title to the property. You could still be accused of being liable for the debts if the creditor can show that it was purchased with community funds.
What if that property was gifted?
What do you mean, if the boat was gifted?
Yeah, let's say my wife's rich.
Well, then it wasn't purchased with community funds, right? Now, if that boat was gifted and it's only was gifted to your wife and it's in your wife's name, then that boat can't be reached by creditors to satisfy the business owner's debts.
Okay.
Remember, the key is community. Also, remember, and we could get into this a little more. I hesitate to get into it because it's more family law related, but a separate debt could be a child support obligation that you have from a prior marriage. Well, then that's a separate debt, so your spouse, even in a community property state, would not be liable for that previous debt that you had coming into the marriage, which was child support. So let's now talk about what your question was, Rick, and that is what's commonly called common law property states, or also known as equity distribution states, because these states want to make it equitable for each spouse. In common law or equitable distribution states, which are any states that are not community property states, debts incurred by one spouse are that spouse's debts alone, and income earned by one spouse does not automatically become jointly owned. So because you're bringing in income during the marriage, which would normally be community and community property states, that's not the case in an equitable distribution or common law property state. So it's the antithesis, if you will, of a community property state. Remember, though, that debts are owed by both spouses only if the debt benefits the marriage. For example, if the debt was for food, clothing, child care, shelter, or necessary household items, or if both parties signed the debt obligation, the loan obligation, well, then it would become a joint debt even in those equitable distribution or common law property states. So remember, key necessities of life or some sort of a signature of joint ownership on the loan docs now transform this separate debt in a common law property state into a joint debt obligation. Okay?
Okay. Makes sense.
So we need to remember that because we really live in this community property state in California. Now, if you're listening to us in some other state that's not a community property state, this is important stuff to you. But I wanted to distinguish it for the community property states as well because it's a vast difference. You are going to be liable for the debts of your spouse if you're in a community property state and you're bringing in and the joint income or the community income is purchasing that debt. If it's a separate debt coming into the marriage, make sure it stays separate. You don't put it in a joint account. Make sure that separate debt is not incurred for specific necessities of life in a community property state. That will make it all of a sudden a joint debt owed by both spouses. And make sure if you have a separate debt coming into the marriage in a community property state, you don't have your wife sign a document saying that she's willing to incur the debt with you if some creditor asks you to sign a personal guarantee of that sort. Don't do it. Okay?
Why would somebody do something?
A lot of people are bamboozled into doing that, Rick. Well, we can really give you this. little extra income that'll tide you over and refinance you. But we can only do it if your spouse is going to be obligated on the debt obligation as well. I want your spouse to sign. You bring it in. The creditors want as much income availability as they can get, and if they can have a second spouse sign that agreement that was originally a separate debt obligation, then they're going to want to do that. Good example would be, let's say you want to refinance your home. And you had your property coming into the marriage in your separate name alone, and now your wife's living with you, you got married, she moved into your separate house, now you want to refinance the home. Well, if the wife doesn't want it in her name as well as yours, which she probably would, even if that didn't occur, the bank may say, well, your business isn't doing that well this year, your income's a little low, but we can get the refinance done if your wife also signs the loan docs and becomes part of the joint debt obligation, even though that home is only in your name. If that happens, now your wife and you are both liable for what once was a separate debt obligation by you when you came into the marriage. If that doesn't convince her to want to be on title, nothing will. Because if I'm going to put my name on loan docs to help you out, I better be on title and own the property as well.
Yeah. So the lesson is to definitely have a guy like Bill review your situation and get yourself protected, right?
Yes, you got to make sure your business is protected, because what I'm trying to really provide here is some insight as to not leaving your business open to become jointly liable for a debt obligation that you ordinarily might not be able to be liable for. If you have a business and you incur a business debt and you have a business entity, generally speaking, the creditor is limited to the asset availability of that business. They can't come after your personal items unless you are committing fraud, or you're not keeping your books, or there's some other way that they can pierce the corporate shield. And that would go just as well for an LLC. So the real value here is to make sure that whether you have a separate debt coming into the marriage or a joint debt after the marriage in a community property state, protect both of them by having your corporate or LLC entity in place so personal assets can never be reached, whether the debt is joint or separate.
Yeah,
makes sense?
Yeah, absolutely. Makes total sense. Well, this has been absolutely fascinating. Before we do the summary, I'm not sure if you're totally done with the topic. But
well, I want to just mention one other item before we close the show, and that is bankruptcy. In a community property state, if one spouse files for Chapter 7 bankruptcy, all the eligible community debts for both spouses are discharged. So I file, my wife doesn't. Everything we own that's a community property joint debt that was purchased with community income, it's all discharged, even if I'm the only one that files bankruptcy. However, in an equitable distribution state, or a community, or a common law property state, as it is otherwise called, the spouse filing for bankruptcy is the only one that has his or her debts discharged. Again, it goes along with the separate notion of being equitable to both spouses. What one does doesn't necessarily affect the other unless there's a mixing of the assets in a joint account, or of course, if there's some obligation that the other spouse decides to incur with you, or if that separate debt was purchased specifically for the obligation of satisfying household necessities, or the necessities of life, as they're commonly called. Okay, I hope that kind of categorizes it for everybody. The big principle, again, Rick, to know is community property states, you're jointly liable for any debts that are purchased with the community income. In equitable distribution states or common law states, the debts are generally separate unless they're commingled or purchased specifically for the purposes of some life necessity. Okay?
Okay, great. Well, before we end the show, I know, Bill, you wanted to mention another one of our sponsors. I know an individual here that is we follow him every weekend.
Yes, we
Somebody
do.
that's close and near and dear to our one of our passions. And
Yes.
why don't you go ahead and talk about
That's
that?
right. That is watch collecting, folks, and you know by now probably that we enjoy that. Jim Skelton is the owner of Strider Watches, and you can look at striderwatches.com to find his fascinating new watch, which is called the Hyperdive. Fantastic watch, made with a great movement, made with all stainless steel, not this cheap aluminum stuff. You can buy this watch with a fantastic lume. It's called Super Luminova, so it glows in the darker hours. It is a super quality watch, and he knows everything and anything about watches, from all the famous brands right down to the more economical brands that are in the market today. Jim is a host, a TV host on World of Watches every Saturday and Sunday from 3 to 6 p.m. Pacific time. You can watch it on channel 227 on DirecTV, and then you can find that website, worldofwatches.tv or worldofwatches.com. But check out Strider Watches. Jim has developed his own watch company, makes a quality watch, top materials, top movements, and you're getting it from a guy who has the watch made here in the United States and who knows what he's doing. And let me tell you, not everybody out there in the watch industry does know what they're doing, unfortunately. So StriderWatches.com. Please go visit him. I'm sure you'll like what you see. Christmas is here. Holidays are here. It's never too late to buy a good timepiece, folks.
That's right. What better way to start off the new year than with a beautiful timepiece like a Strider watch, right?
Right. All right, Rick. Well, next week we'll have a great show as well. We want to wish everybody a happy New Year. We hope you really enjoyed the Christmas holidays and the Hanukkah holidays. We wish you happy Hanukkah, Merry Christmas. We hope you have a prosperous New Year. We'll be here to bring it in with you. So until next week, have a great, prosperous week and a happy, healthy start to the new year.
All right. Happy New Year, everyone, and we will see you in the new year. Take care.
Okay. Right. Bye-bye now.